So this video is going to look at the Supreme Court and precedent. So first of all, we'll keep it fairly simple, just go through the factual content. The case of London Street Tramways in 1898, so old, said that the House of Lords, which was the old name for the Supreme Court, House of Lords must follow its own past decisions. So we've talked about how courts lower in the hierarchy have to follow the higher courts. Well, the one at the top, the Supreme Court, still has to follow its own past decisions. So London Street Tramways 1898 says you've got to follow. That's it. You have to follow your past decisions. Great, you've got certainty, but actually you've got no flexibility to change the law. That decision is going to stand forever. But in 1966, the Lord Chancellor issued what was called a practice statement. And the Lord Chancellor said in this practice statement that the House of Lords can depart, in other words, not follow, their previous decisions, quote, when it appears right to do so. Nice and clear. So when it appears right to do so. This means they don't have to follow their own decisions. They're being very cautious about this because the Supreme Court, these are respected judges. They are legal academics. They have had a lifetime in the legal profession. So judges are cautious about using it to overturn their own previous decision. And they're unlikely to do it unless there's an error. You just need to be aware of this term. The practice statement was changed in 2009 when the Supreme Court was created, and they've just called it Practice Directions 3 and 4. So just refer to it as that, but go through London Street Tramways, the practice statement, and then make the point that it has changed its name. So the first major civil use, in the case of Addy and Dumbreck, they were looking at child trespassers. Is an owner responsible for injury when children trespass on your land? And what they decided was, in Addy and Dumbreck, they said the occupier of land only owes a duty of care to child trespassers if the injuries were caused deliberately or recklessly. So, some years later, in the case of Harrington, the House of Lords looked at this and they were unhappy with this decision. So they changed it. They used the practice statement and they said occupiers do owe a duty of care to all children trespassing. So they have overruled their previous decision by using the practice statement. The first major criminal use was in the case of Shivpuri. So the first case was Anderton. Anderton said you cannot be guilty if you attempt an impossible crime. So if you try and do a crime that's actually factually impossible to do. So Mrs. Anderton tried to she was trying to handle stolen goods. She thought she was handling a stolen video recorder, but it wasn't actually stolen. So it was impossible for her to handle a stolen video recorder. And the House of Lords said, you can't be guilty of a crime. So you're okay, off you go. Now, some years later, or it was a year later, actually, not some years later, Shivpuri said, we don't like this decision. We actually think it's wrong because in Shivpuri, he thought he was transporting drugs, but it turned out they weren't actually drugs. It was like vegetable powder. And if you follow the decision in Anderton, can he be guilty of attempting an impossible crime? No, he can't. But the House of Lords used the practice statement and said you can be guilty of attempting an impossible crime. So now that is the law. So they overruled their previous decision and said that is now the law. So if you try and attempt an impossible crime, even though you can't actually do it in reality, so you try and kill someone who's already dead, can you be guilty of attempted murder? Yes, you can. And that is now the precedent. That is the law set in Shivpuri.